Good afternoon, everybody. This is Omar Serrato with the Tilted Lawyer podcast. Happy Thursday to all of you. My phone has been blowing up about this granting of the motion to strike Freedman's letter. And really, I read it. I talked about it last night with Laura Knighty about what I thought was going to happen with it. I mean, I didn't know about the. I got. Yeah, I didn't know if they were going to strike the letter or not. But I just know that them striking the letter has nothing to do with the motion to quash. It has nothing to do with the merits of this case. It has nothing to do with anything other than Freedman just kind of got smacked in the hand by the judge with this letter. And before we get into all the opinion stuff and speculation and stuff, let me pull up the actual affidavit of Bryan Freedman. So this is what he was willing to say under penalty of perjury. And this really kind of goes more towards the merits, not his letter, but the merits of the subpoena that they're fighting in a completely different district. In his letter, he wasn't asking Judge Linman for relief. I guess he was just giving an explanation. The judge didn't like that it may have contained defamatory statements with no explicit purpose because he appeared to not be asking for anything that the judge could do anything about. And so what more would it have been than an attempt to maybe draw the ire of national media so that they can all speculate about how Blake Lively is an extortionist, threatening to release 10 years of text messages and all of this. So Bryan Freedman doubles down. And interestingly, I don't remember if he didn't strike his declaration, did he, Anita?
He did actually. I think
the declaration and
they responded within the hour of the declaration.
Oh, no.
And I think they were striking the previous document, and then in the meantime, probably Freedman submitted.
All right.
And then they just added as a note that additionally to document 217, they're also striking 219 and 219.1.
Okay.
Wow, I know too much of this. The numbers.
It's all right. Okay. It's all right. Here, I'm gonna share my screen, and hopefully this is the right one. Yeah, this should be it. Not this one, but this one. All right. So this is his affidavit. Look, I mean, it's stricken. It's stricken from the record in terms of the docket, but it's not stricken in terms of its merit. What the judge basically is stating that these kinds of conversations and documents, they could be submitted confidentially without becoming like this big public spectacle. I think that's what this judge is signaling to everybody, that, look, don't take advantage of the laws, that you could just basically state whatever stupid allegation you think that's unsubstantiated by facts or evidence and use it as like a PR stunt. Pretty much what he's accusing Freedman of doing. And this is what he states. He doubles down on his letter and he supports it with an affidavit. Say, look, I didn't just conjure this out of thin air. He says, I'm a partner of Weiner Freedman Tailman of his firm. I represent all of these people. I submit this affidavit in opposition to the motion to strike filed on May 14th, which was yesterday, by Blake Lively regarding my May 14th letter elaborating on the basis for the Wayfair Party subpoena to Venable LLP. On February 14th, I received a voicemail from a person very closely linked to Taylor Swift, whom I subsequently called back the same day. Now, out of respect for the individual in question, I am not identifying them at this time. However, should the court direct me to do so, I will comply with the court's order. I laugh because this is exactly how I said Freedman was going to respond when I was talking about this with Lauren yesterday. Look, I have a guy. I'm not going to reveal his identity, but if you want me to, I will. Just what he's saying here. And then he outlines it. Look, during this February 14th phone call, which lasted approximately 1 hour, the speaker told me that they had been informed that J. Douglas Baldridge, counsel for Taylor Swift and a partner at Venable LLP, had received a phone call from Michael Gottlieb, counsel for Blake Lively and Ryan Reynolds, during which Mr. Gottlieb requested, on Miss Lively's behalf, that Taylor Swift make a social media statement in support of Miss Lively, given her absence from the Super Bowl that year, and stated that if Miss Swift failed to do so, Miss Lively would release 10 years of private text with Miss Swift. The individual also told me that they had been informed that Mr. Baldridge had accused Gottlieb of extortion and ended the call. During the same February 14th call, the individual told me that they had been informed that 4 or 5 months earlier than that, Miss Lively had requested that Miss Swift delete her text messages with Miss Lively. I was connected to this individual through a mutual friend who informed me that the individual wanted to talk. We've had several phone calls since the 14th. On a later call with the same individual, the individual told me that Mr. Baldridge had sent a written communication to Gottlieb relating to their phone conversation. My office issues a subpoena to Venable LLP for the purpose of seeking the aforementioned written communication, and he's putting this basically under, this is his offer of proof that I was talking about yesterday that was forthcoming. And then you say, and by the way, I don't think I gave you a proper introduction. I'm joined by Anita, the Redditor internet sleuth, who has a whole website dedicated to this case and her theory of the case. She knows virtually every single detail about everything that's gone on with the parties in this case. She knows it better than I. She knows it better than you. She knows it better than anybody that I've seen covering this case. And she's joining us here on the show. She's a treasure trove of information regarding the facts. She's like a walking Lively versus Baldoni timeline, and she's joining us all the way from overseas. How are you, Miss Anita?
Hi, what an introduction. Wow.
Well,
thank you.
So I have that about an hour after that declaration is filed, we get this order from the judge that I'm going to share with you right now. So this is Judge, well, wait a minute. That's the, oh, is this the right thing? I just want to make sure. No, I'm still have the affidavit on the screen. How do I get that off? All right. Share. This is what I want. I think. Yes. Okay. So this is the order from Judge Linman. This is what he says. Look, Blake Lively moves to strike a letter filed on this case yesterday by Bryan Freedman on behalf of the Wayfarer parties. The motion is made pursuant to the court's inherent power to prevent abusive or improper use of this docket. The motion is granted. And he goes on to explain. Courts have inherent power to manage their own affairs so as to achieve the orderly and expeditious disposition of cases. This includes the power to strike materials outside the pleadings that are abusive or otherwise improper. And he cites this long line of cases. The Second Circuit has emphasized that courts should protect the judicial process from being co-opted to promote scandal arising out of unproven, potentially libelous statements. It has stated that a district court has not only the power, but also the responsibility to exercise supervisory power over its own records and files to ensure that they are not used to gratify private spite or promote public scandal, or serve as reservoirs of libelous statements for press consumption. This is really a unique legal issue that is truly unique to cases involving public figures. Whenever you file something on the docket, and you'll see like a title, and you could see what's been filed or whatever, and what's being alleged, it's really not that big of a deal because nobody cares unless it's somebody of public interest. And then like the Daily Mail picks it up and, oh my gosh, Blake Lively is extorting Taylor Swift, threatening to release 10 years of emails. And so that's really what they're getting to. Whether or not it's going to have the effect of tainting the jury pool, I'm not so sure about that. Because quite frankly, I don't think that there's enough people that know about this case and the finer details of it that are paying attention to the actual docket of this case as the days go by, that it's going to be affecting them come trial. So the judge goes on to say, the letter is improper, it must be stricken. It is irrelevant to any issue before this court, does not request any action from this court. They reference this case, Morse versus Weingarten, striking reference that serve no purpose other to inflame. It concerns a subpoena proceeding in the District of Columbia, over which this court has no authority. The sole purpose of the letter is to promote public scandal by advancing inflammatory accusations or information and belief against Lively and her counsel. It transparently invites a press uproar by suggesting that Lively and her counsel attempted to extort a well-known celebrity. Retaining the letter on the docket would be of no use to the court and would allow the court's docket to serve as a reservoir of libelous statements for press consumption. The same is true for the Wayfarer party's subsequent submission at docket number 219, which the court will strike sua sponte for the same reasons. The Second Circuit has noted the court filing may be abused to make potentially defamatory statements without the threat of liability, giving that under New York law, absolute immunity from liability for defamation exists for oral or written statements made in connection with the proceeding before the court. It is advised the press accordingly that although the act of filing a document with a court might be thought to lend that document additional credibility, in fact, allegations appearing in such documents might be less credible. I mean, I guess they might, but he supported it with the declaration and everything. He got to be fair, that seems like a really weak source of information, which is usually what offers of proof are. Offers of proof leads you to search in certain directions, and you're either going to find relevant stuff or you're not. So it's not like anything earth-shattering. Hey, I talked to a guy that said that Taylor Swift was extorted. Oh, great. Well, let me just try to subpoena some of those written communications. Fine. Is there a way that Freedman could have proceeded without drawing the ire of the judge? Yes. Was this a calculated move on the part of Freedman to get this out there? Knowing that people were going to pick up the story and start talking about it in a way that was damaging to Lively's side? Possibly. I even raised the point yesterday that, if he wanted to just like make a PR statement, he could have just like called TMZ or something, and they would have taken his statement and ran with whatever he was going to say. But the judge is right that you have a certain level of immunity when you file stuff for purposes of the court docket to just say stuff. And if you have of the mind that the media is going to pick up on these filings and run with these stories in a way that shields you from liability for possibly defaming somebody, that's problematic. And that's why the judge is coming down so hard on Freedman with this. He closes it with motion to strike is granted. Clerk of the court is directed to strike docket number 217. The clerk of court is additionally directed to strike number 219, which was his declaration, right? Yes, it was his declaration. Counsel is advised that future misuse of the court's docket may be met with sanctions. So that is not an idle threat by the judge. If something like this happens again, somebody's getting sanctioned for something. So with all of that being said, what does all of that mean? It doesn't mean shit. It means nothing. It literally means nothing to the merits of that motion to quash. It means nothing to the merits of this case. It means nothing of the merits of the evidence that Freedman is seeking or his source where he found out that he should be looking for certain things. It affects nothing. This is the judge coming out and playing referee, stating that I'm not gonna look. It's like they're boxing right now. No rabbit punches, no hitting behind the head, no low blows. He's telling them to knock it off. Next time I'm going to deduct a point. That's basically what's going on right now, to use a boxing analogy. So what do you think of all of that, Anita?
I think it's highly hypocritical of lively parties, but I think, to be fair to Freedman, Lively came running to the judge saying that, hey, help us get the motion to get quashed, I guess, in whichever other district.
Yeah.
And then obviously Freedman has to reply.
I agree.
Because then also if he doesn't give any information about it, why, right? Wouldn't he have to explain why?
No. Well, it's tricky. And I'll explain. By the way, Carmen Trammell, thank you for becoming a YouTube member, a brand new member. Appreciate you. Yeah. So whenever you're going to, you got to be really careful. Some judges are more sensitive than others. But in a case like this, where there's content being made every single day on the merits of this case, every time any stupid little thing gets filed or updated to the docket, YouTube creators are running with it and posting it, and people are talking about it. And so it's not so innocent. In a normal case, I don't think that a judge would really give a shit because nobody's like checking on the docket that hard. In a case like this, I think you might signal to the judge that I would like a chambers conference to discuss. In which case, you would have private communications with opposing counsel there, either a conference call with Judge Linman or literally going to the courthouse to do oral arguments and discussing in chambers, meaning off the record, not in any court transcripts, his offer of proof. I got to tell you, Judge, I got a source. I had a phone call. It sounds to me that Taylor Swift, a potential witness in this case, might have been tampered with. I don't know to what extent, but it seems to involve extortionist threats of releasing 10 years of text messages. I don't want to put this in a letter that's going to go on the docket. I'm just letting you know that I have an offer of proof that you could run with if it would be helpful in you deciding whether or not to quash this case.
I object to you to what you're saying. I'm going to give you, so you're saying a legal perspective. Let me give you a public perspective.
Oh, well, are you objecting as the public or as the judge?
As the public. I object.
Oh, well, then overruled. How about that?
Oh, okay. Oh, damn.
No, but go with your... All right, okay. Yes, you may object. Go with your thing.
So I understand what you're saying, but I have to give you the public. Like, I think everybody, sorry, I interrupted, but like, I thought like you were coming to an end. I just got too excited again. So remember the Taylor, right?
Yeah.
People linked the Venable LLC to Taylor before even it was disclosed that it was to Taylor. People immediately linked it.
Yeah.
Okay, so I just have to give you a public perspective. People have linked it, they understand. Immediately, you can see it's like, oh, they're bringing Taylor into this. They're just trying to get the name, whatever, right? So this is the PR thing. Everybody started talking about this before Freedman even mentioned this extortion thing.
Yes.
What does he do? The Swifties, the dragons, and the mini dragons, you know, that literally, if you go online, even yesterday, Lauren said they're horrible.
Yeah.
Like the way they attack and the way they are. And this whole lawsuit is in the public eye and in the court.
It is.
So until they get to the court for a year, it is, it's quite like, let's say if until they get to the court, they still maybe like in a couple of months or something, they might start leaving their houses, right? For the first time, Justin Baldoni posted a photo and everything. So if they don't explain it when it has been publicly available that this is what they're trying to quash the motion, like, wouldn't it be right to say why they're saying when the other lawyer is saying, oh, they don't have a reason? Here's my reason. Yeah. Because like, for me, that makes sense. Freedman actually asked subpoena on the 28th, or like sent the intent for subpoena on the 28th, subpoenaed on 29th. They must have been talking in between, like, you know, and then Freedman said that, oh, we're communicating in good faith with Venable now. But then Lauren Lively came and said, oh, Judge, so there were 10 days in between where the subpoena. So if Freedman really wanted to do it publicly, he would have. Don't you think? Sorry. Did I make sense?
Yes, but I can tell you this. You're not wrong in what you're saying. You're certainly not wrong. And Freedman look, I don't even want to say that Freedman is wrong. He's trying to let the judge know in the way that he's used to doing it that, hey, this is my offer of proof. He submits when an attorney submits a declaration, they're attempting to act in good faith. Like, I'm putting my ass on the line and telling you this is what I have. And all what Judge Linman is doing. Look, Judge Linman, you, the public perspective, and me, and everybody not involved who's not a party or an attorney of the parties in this case, is a pain in his ass. Every time that some sensationalistic story drops in this case, it presents a threat to the fairness of a trial that is in his courtroom. And so he could give a shit about what you know and what you're allowed to know. He'd rather keep all of the sensational stuff out of wraps. He understands he can't control all of that. And he spoke eloquently about it at the last hearing regarding protection orders for attorney's eyes only stuff. But he's saying that, look, we were going to have oral arguments on this. This is what I think that he's thinking. We were going to have oral arguments. You could have asked me to go off record. You could have approached, even in TV trials. Very often in criminal trials, you'll see the attorneys approach the judge and they'll speak off the record to discuss stuff that they don't want the jury or the public to hear. And this would have been an appropriate occasion for that. It doesn't affect the judge's thinking. He still gets the judge is the most important person to get all the information to. And Linman is just saying, don't use my docket to get sensational stuff out there. You bring it to me in my chambers. If it becomes a thing, it'll become part of the pleadings anyway, because it'll be substantiated. But you don't just make libelous, defamatory statements because you're protected by litigation privilege. After everything that's gone on that I've warned you about, my previous admonitions, and the fact that this is quite possibly the most famous case of this decade. That's all. So
if they didn't want this information to come out, then the Gottlieb side could have done this under seal, and then Freedman would have replied under seal. That's what I'm saying. Like, okay, I understand the Freedman's decision. I don't disagree in that sense that it is quite, how to say,
but I guess the difference is, but you're not going to like my answer because it's from a legal perspective. But when Lively filed that, and they were literally asking the judge for some measure of relief. There was a purpose for it. And they weren't getting too much into the gritty details. Freedman came back and said, no, I object to that because of this and reasons, and here's my declaration and offer of proof. I think what Linman is highlighting the fact that you understand the nature of this case, about how sensationalistic it is, and you know better than to drop that on my dockets, and you're too savvy of a PR individual for me to just give you the benefit of the doubt. I think you knew what you were doing. Next time, bring that to me in chambers before you release it in a filing to my courtroom. That's all he's saying. And the next time you do that, he will be hit with some kind of sanctions. I don't know.
Okay, I'm gonna give a very, I don't know, maybe this is how I viewed this. Like, you have two kids, and then there's the very strict father. One of them is like this, has a blabbermouth. This is the Lively side, obviously, who has been PR. And the other one is actually the good person or something. Maybe, he sometimes gets into trouble, but it's not nothing that's, let's say, criminal. He says a few words.
Yeah.
But, and then this time, Lively parties come and is like, oh, yeah, I did this. Oh, help me, tell him to shut up or like stop it. And then the other one person comes and calls the other person a B, and like calls them a bitch. And then, and then the father doesn't disagree with the son, or I don't know, that he just says you can't say that word, but he doesn't disagree with the description of what the other person did. And I think this is like the simplest way I could explain what this strike means.
Yeah.
Right?
Well,
like he doesn't say that it's not stricken based on its merit, like you said. That's a legal word.
Yeah, it's like, don't be saying airing dirty laundry out to the public like that before I've had a chance to know what you're going to say. By the way, everybody loves you. They're like, Anita is voicing the public's outrage. They're really glad you're here because they want to say everything that you're saying. But using your analogy, it's like, the brother and the sister are fighting. And then, they're going on about stuff. You're trying to get to the bottom of it. And like the whole family, because it happened at like a Christmas party or something. And then one of the kids is like, well, she peed the bed. He's like, don't you be saying stuff like that in front of everybody. Even for, you want that stuff. There's certain stuff that's not relevant to the immediate situation that doesn't need to be aired to the rest of the family. And you want to police that stuff as the parent. That's what Judge Linman is doing in this case.
Yes.
Don't do that again or you're going to get a whack. Like with sanctions. You know what I mean?
It was a tiny slap on the wrist. It wasn't
a slap on the wrist.
It wasn't a beating.
No, it wasn't. It was a stern. Don't you do that in my courtroom ever again, counselor. You know better than that. Next time there's going to be consequences. That's all. That's all it was. And you know what? As attorneys, you toe the edge sometimes. I have been guilty of doing that myself. There's times where I don't give a shit about it against the rules. You said this stuff, so I'm going to say this stuff. I'm going to make sure everybody hears it. And then the judge said, counselor, that's enough. All right. But they started it. It's literally how it starts. Like, I feel like your argument is basically, yeah, but they started it. And it is. Like, at its heart, that's what you're saying. And it's true. They did start it. And I think that Freedman made at least an effort to try to do the right thing by filing a declaration. Maybe he realized what I realized yesterday is like, hey, that's kind of a weighty accusation there. He better support that with an offer of proof. So he gave him an offer of proof. And then the judge is like, don't do that. You've been doing this for too long. You're too savvy of an attorney to not know what you just did. So stop it. And the next time it happens, you're going to be punished. That's all he said. Does it have any merit whatsoever or affect the merit whatsoever of this case in any way? Nah, it doesn't. The judge is going to hear all this stuff anyway. And the judge is the most important person to receive the information. He's the one making these rulings on the motion. So there's nothing to get up in arms about. This is just the court, the judge taking control of his courtroom. That's all. He's policing.
Legal question.
Yeah.
Or not legal, procedure question. So since they filed this on the 12th, 13th, 14th, so it happened in 3 days, does this mean the judge has been reading all the filings as we go?
Yes.
Or is there somebody reading and then saying like, hey, look at this?
Oh, no.
And then, no?
He's reading them.
Every day. So as they file, let's say they file on a Monday, has he read them that week?
Well, they prioritize.
Yeah, that's what I want to ask, because he hasn't replied to many things, just this one immediately, right? Yeah. Within the hour, as I said. So I was curious, how does that work? What does that mean for the other filings? A
motion to strike is a pretty big deal. If you're asking for a motion to strike something that's on the docket, you want to address that right away, because you're not going to address that a month later after it's been on the docket for a month and all the harm is done. It's almost like an emergency ex parte. Let's just see what this is about. I'll rule on it right away, so whatever damage is mitigated. And so they dealt with it right away. But he's still collecting information. They're presumably going to have oral arguments on the motion to quash. And that would have been perhaps the appropriate time to submit his offer of proof. Freedman could have offered it under seal. He could have done that.
Yes, so Freedman is playing two, legal and court. He had to do it. He could have done it for the court, but he's battling the public PR. That's like, right now, I think they're paying, triple the amount to their PR agencies to battle this. So he has to throw some punches here and there. And actually, Freedman hasn't stated anything in the public, because I think they're literally right now trying to get all the reply to the interrogatories, whatever, right? So that's what they're doing. It's Lively and Stephanie Jones's legal teams who are just running their mouths around, and then they're the ones who are making appearances. They're the one. Technically, Freedman, whatever he did, he only replied to. I understand what you're saying, but if you take a step back, Freedman, I think he knows he won the public PR war, but he still has to this tale again. Swifties, the dragons. Lively was not joking about the dragons, right? The good thing about the Ryan's dragons is that it's more in the comic world. They don't care about this. If you ask anything about them, they're like, oh, it's okay, we love Deadpool. Swifties, they're ride or die.
Yes, they are.
They're like little whack-a-mole kind of thing, you have to just
I'm learning about the Swifties. I haven't drawn their ire yet.
And ever since they connected it to Taylor Swift, Venable, he had to. I think he had to.
I agree with everything you're saying. I was even saying that yesterday with Lauren, that Freedman has been pretty quiet. The Lively parties have been making all the noise. They're the ones filing all these motions, these 12B6 motions, all of this stuff on the docket. Freedman's just been kind of just doing whatever and going with the flow, nothing too sensational. And yet we're finding out all of this crazy stuff, sham subpoenas and this and that. And now Freedman has this opportunity to let everybody in on the fact that, hey, it gets a lot deeper than that. I have a source that's telling me that Taylor Swift has been extorted by these effing people. And let me tell you about these 10 years of text messages. He didn't. Yes, I think he knew what he was doing. I think he did it on purpose. I don't think he cares about this admonition. I mean, I don't think he's going to do it again, but I think that he did it knowing that it was going to do this. Maybe the judge was going to strike it or whatever. Fine. He could have offered it under seal. He'll probably be doing that a lot more now. I'm not even discounting the fact that he might have offered a bunch of stuff under seal that we don't know about yet. There's a lot of things going on behind the scenes that we don't know. Now, this happened to slip out, and, it is what it is. I'm just saying that you're not wrong in your assessment. The lively parties have been the squeaky wheel this entire case. Freedman's has been litigating pretty, I don't want to say boring. He's just been under the radar, monitoring. He's litigating as if he's winning the case. The lively parties are litigating as if they're losing the case with the things that they're filing. Their refusal to make certain concessions that you would normally make to just about anybody. It's really telling. And so this one thing that Freedman states about this extortionate threat, and like hours later, motion to strike and this and that, and then the judge is like, hey, Freedman, you know better than that. What are you doing? And so we don't even know everything. All I'm saying is, don't get too excited about this motion to strike being granted. It really doesn't mean anything in the grand scheme of things.
Thank you.
Yes,
I think if I say that wouldn't mean anything as a lawyer, I think it makes more sense. And also, I just want to highlight everything that I said. It's very funny to me that, or maybe funny, ironic, right before something probably Freedman is going to file, it's the lawyers of Lively and Stephanie Jones are going into the PR. They're talking in public because they know it's coming up. That's what happened with the digital forensic things as well,
Oh, yeah.
And then the subpoenas have not been presented yet.
No.
Yeah.
What do you think of that?
Well, I said when I called it has I think it has never been properly issued even.
Maybe not.
I think this is what it is. Like, again, I think they're trying to get out of this. They're keeping it to the last minute. And my thing, I don't like this, but I think there's just no way Lively and Reynolds, they would go to court. They're going to do the depositions, probably. I think they might try to find something to see if they can kind of back up their claims.
Yeah.
And they will not find, because, again, so far they haven't found anything.
Yeah, it's looking worse and worse. It really is for them. I mean, very clearly. I mean, I don't know anything about Lively and Taylor Swift and their friendship, but the things that I've seen leak out, Taylor Swift is clearly not happy.
Oh yeah, and I was actually one of the things I want to give you a bit background of my website thing. What I've been doing is like I have a spreadsheet of timeline. I think I have found out who are their insiders in the Daily Mail and stuff, because I've compared all the the things that were coming out in the PR war that was happening in
your website again.
Oh, right now I need to update. It's Anita's Theory, anitas-theory.com. But I'm updating the timeline because there are some things like so many things have come up that I need to update on the daily. And I've started having anxiety at the thought of being wrong, because once I put it out there, people, I don't want to make mistakes. So I've decided to break it down. But basically, this whole also, sorry, I lost the train of thought. Never mind.
No, you're good. Hey, don't worry about. Look, if you're making theories, you're going to be wrong about a lot of it, but you're going to get a lot of it right too. Like, you've been wrong about certain things, but you've also been right about a substantial amount of stuff that lends credibility to you. Especially if you're just making a website, you could just make changes as you corroborate more things and find out what's right and wrong.
I just don't want to be sued for it. Like, I'm not American and I don't know how to deal with this.
You're basing it all on
literally like I've made a disclaimer that these are all my opinions. Please do your research, blah, blah, blah.
Yeah.
And another thing, imagine everything we have found out about Blakely via public research. Can you imagine what is happening, what is in her phone? I can't imagine.
Yes, it's man, I don't know. It's like I'm telling you, we are seeing like the tip of the iceberg in terms of what's actually happening in this case. Like we're getting little bits and pieces that fall out of the bag, but inside the bag is like a treasure trove of information, and that's what the trials are for. You know, I mean, we speculate on these things, and we have these crazy theories and these crazy allegations made by everybody against everybody, and we don't know, you know, the merits of really any of it. That's what the discovery is for. A lot of the stuff that's been going back and forth between the attorneys and the judge, I promise you, like the most compelling stuff has been under seal. And so, I mean, we know generally what's going on, but we don't know all of the details.
Can amended complaints be under seal? No.
In very limited circumstances. And even so, even then, not really. Like you could keep victims private. Like, for example, if the victim was like a minor or something, you keep their identity out of the pleadings. But pleadings are largely public record.
Okay, then I have another legal question. So let's say they go to discovery and right. So CRD complaint happened, everything that's in the CRD. Yeah. What if they find something like, I don't know, it's completely irrelevant to this, but then they add this, this goes, and then they change their initial complaint. Can Freedman still pursue defamation because it shows that, they dropped everything they were claiming in the first place?
Not necessarily because of litigation privilege.
But a CRD was not a litigation privilege. And then YT was not a litigation privilege. Because if they can prove that, if they can still prove that all of these things didn't happen, right? Wouldn't that separate the actions? Because right now they're consolidated. Am I making, do you know what I mean?
No. So your question is, what if they make all of these allegations in an original CRD complaint and then substantially drop most of it and change it to something else in the amended?
Yeah.
I'm pretty sure that would still be protected under litigation privilege. But
they also did the defamation, not because of the lawsuit, right? They're saying that it happened in August, and they're saying that, there was extortion, all of this, and defamation.
But that was the stuff that was leading up to the filing of the CRD. The CRD itself is not defamatory. Because it's a complaint.
The New York Times article and the smear campaign is defamatory because they have the text messages that show that they don't have.
Well, yeah, but those wouldn't be on the basis of the complaint. That would be on the basis of the events that happened before leading up to the filing of the complaint. Does that make sense? Am I even understanding your question correctly?
Yeah, I know. I think maybe, I think now you're making sense to me. So Blake Lively can, although let's say she is, what if she drops her sexual harassment in this case?
Oh, well, she can't just drop it unilaterally because...
That's what I mean, because there are causes of action.
Yeah, well, I guess I'll give you an example. If she filed her complaint and then amended the complaint before he responded, then she could drop whatever she would want to drop. Basically withdrawing her complaint and then filing a new one. But since they responded to the allegations in the first amended, if she wanted to just drop those causes of action in a second amended complaint and proceed on some other stuff, she's still on the hook for the causes of action that were answered because it cost him to have to defend himself, attorney fees, cost, and now he's pissed off, and now he actually may have been defamed. And so we're going to have to, and again, it's not because he's been defamed by virtue of the complaint. Like they're stating they've made all of these out. Like the basis of his defamation complaint is that they were doing all this stuff before she ever filed. And then part of your theory is that she used her complaint as a prophylactic move to guard against what she knew was potential litigation against her in the future for the defamatory stuff that she was already doing. And so it's complex, but it's not really. She can't just say, yeah, just kidding, and dismiss and let me out. No, because now Baldoni has countersued, and he gets to have his day in court as well. If they want to dismiss, they got to both agree to dismiss.
Yeah. Okay. Yeah, that's what. Yeah, I just have. I think they're gonna settle. This is like, I would love for them to settle in. Lively is gonna push, not Baldoni, but they're gonna settle under Freedman's conditions. I think that, whatever it would have. I think he will get probably a half-ass apology. I don't love it, but I think this is. Hopefully Baldoni doesn't do that. But again, when we're talking about Freedman and Freedman, let's not forget Baldoni, Jamie, and even Sarwit's faith. They're like very faith. They're all about forgiveness and everything. Yeah. What if she does this? Unfortunately, not maybe fortunately, because we finally have a good person we're all kind of rallying behind. Yeah. I just have a feeling that he might settle for a half-ass apology in a way.
I don't know. You didn't settle for no half-ass apology when we were role-playing.
No, yeah, that was me, Freedman, right? I wasn't Baldoni.
This is like, no, I want.
Yeah, I hadn't passed on the message. I hadn't passed on the message. I know my client. I was fighting for him the way I would have fought for him, and yeah. So anyway, that's what I think. Because again, what we know is already just so massive, and it's the tip of the iceberg. And I want to just list off the shady things that they've done since August 21st.
Do you have a list like that on your website? I got it pinned in the.
No. I actually made a Reddit post about it after this affidavit.
Oh.
So what we have, like, I need to update my website. If I shared my spreadsheet with you, you would be freaking shocked what I have.
So, Anita, I needed time to digest all of this.
No. Okay, no, I'm not gonna show you my. That is my spreadsheet is to organize my brain, so that I can deliver it in an orderly fashion. So,
I understand.
And this is like the minimum things. So what we have is Leslie and Stephanie Jones confiscating the phone, right? After they didn't sign the apology. And yes, maybe, okay, legally, maybe not. I'm just going to say what we know, right? And so far, Brian hasn't lied to us, the public, so far. Right. I haven't seen. He may have, I was thinking about it, that he hasn't even exaggerated. He just, or like PR, PR way, relayed the information.
Yeah, he's made PR
and
moves.
He hasn't even exaggerated the things that he has. He has like maybe embellished how he is but he hasn't exaggerated the level of things. That's how I feel, or how I understood. And it's been 5 months, right? And so far, whatever he has said has come out. Anyway. Yeah. So we have the confiscation of the phone because they wanted this. We have the Van Sham on the 27th.
Yep.
We have a CRD followed by a right to sue, which was signed actually by not by Lively, but by her lawyer, Ezra Hudson.
Yeah.
We have immediate cease and desist on December 20th, actually, after the CRD, before they went to New York Times. They have 2 cease and desists. They have the fight for blanket AEO, blanket everything, right? They have said that, we're going to show you evidence. They haven't, whatever they have shown as a text message in their CRD and the initial complaint, they haven't added any additional, let's say, screenshots or photos. They just have words describing things. And again, then there's the awfully protected 47.1, right? Like the shocking. The alleged access to Abel's communications included her communications with her counsel, right?
Right.
And it's not just the words that Freedman has said it. He has subpoenaed the company, security company, right? I also did some research on the Selbit. I want to ask you.
Okay.
Not showing the subpoena so far, and now allegedly extortion of the tailor.
Yeah, that's a lot.
So this is a list of things, shady things that, and I'm not even talking about this was the thing that immediately just popped to my mind. This is the person who has done the CRD and said that, there was a smear campaign and sexual harassment. And even her CRD complaint is not signed by her.
Yeah.
And Lively, this is their party, right? And then the Freedman side, they have 2 sworn affidavits already.
Right.
Like basically saying that this is what we have. And they haven't, like, they have the screenshots of the full messages and everything. And just take a step back and like look at the situation. How was this not preemptive? Like, why would a lawyer, another, like everybody says, yeah, it's not, it's unethical, but it's not illegal, right?
Yeah.
If she really believed that, she could have actually gone and filed a lawsuit or something that way, actually against Baldoni's PR team. Why do it through Stephanie Jones? She already knew. Why go and why not do the Van Zandt? What is it, Van Zandt? Right? Why not Van Zandt?
Yep, the sham lawsuit.
Yeah, she could have filed Van Zandt under. I mean, she could still have filed Van Zandt and requested subpoena from Melissa and Nathan Abel, like, you know, Jennifer Abel and stuff. So why go to Stephanie Jones? And that's the thing. It's just. Sorry, like this is just like a thing that why go through all of this if you're not lying?
If who's not lying?
And Blake Lively, and why go through all of this if you genuinely believe this is what happened, you know? Yeah. And why go through all of this if this is not to protect yourself?
Well, the main reason why you litigate is for 2 reasons. You either think that you're right, or you're seeking to intimidate. And to litigate, you're either litigating to win, or you're litigating to force somebody into submission. But if it's to force somebody into submission, they've ran into a worthy foe. They're not. Freedman and the Wayfarer parties are not submitting to anybody so far. They've been worthy adversaries, and so the script has kind of been flipped. If we're litigating on the merits, like who's going to win, it seems like all the shady stuff that's going on with respect to this case has been on the Lively side, as far as I can tell. It kind of fits the general personality profile of the parties, respectively. Baldoni being who he is, a man of faith and champion of women's rights, and Blake Lively, who's been known to be problematic on the set, and Ryan Reynolds, who's known to be been problematic to those around him. And you have people that have sought to intimidate for years now, it seems like. This is just the way they do business. And if that's the way you do business, there's an awful lot of corroborating evidence that they're going to have to sift through. That one wouldn't have to stretch too far to imagine a scenario where they were attempting to extort Taylor Swift with 10 years of text messages and filing sham subpoenas and sham lawsuits and otherwise. I mean, those were deliberate actions. They thought they were getting away with it. And you know what? Under like 90% of the time, they probably would have. It's just they ran into a buzzsaw, and now we're here. And they're litigating like it. They're litigating like they're angry. They're litigating as if they're the ones that are in trouble, and they're sick and tired of it, and they're just throwing everything they can at the wall and taking shots where they can. I promise you, they're looking at this motion to strike being granted as a win. It's like, oh, that felt good. They needed that. They needed that for their psyche to continue with this case because
they needed the PR for them. Oh, you should have seen there's this subreddit. When you read there, like you lose all your brain cells. I'm not even going to name it. The way people, how they're like trying to say, look, the judge has stricken the thing. Oh, it's just anyway. But
how do you
by the way, my theory, I'm calling it my theory, but amongst everything else that. For me, once I found out that in September, Reynolds was trying to buy the movie rights right after apparently the smear campaign, for me, that sealed the deal.
Yeah.
And the fact that actually that the articles were around the 5th or 6th to 16th of September, and then Van Sham was filed on the 27th. This was preemptive, because why try to be nice to the guy who apparently has been sexual, or why call him names that you like, why call him a director when you have been not calling him a director? Like, you know, why be nice to him for a second?
By the way, before this all started, I had no reason to think that Ryan Reynolds was a bad guy, or, you know, a kind of guy that would behave the way that he's been behaving. It's been really enlightening. I mean, I never cared to know him in the first place. I had no reason to like or dislike him, but he's not a very likable guy with what's out there.
Because we didn't know. That's the thing. And that's the thing, the PR thing. I think we have first-hand, like first row seat, or like to understand what actually PR does. We saw their messages, first of all, how they function, right?
Yeah.
So
he's a bad actor, but not a bad guy. I don't know, Rob. I haven't really watched many of his movies.
I to be honest, like, I like Deadpool in the sense, I like it's funny and it was different, but now I'm looking at it with a different perspective, right? Now you see how he got there, how that's a different perspective, and they've been manipulating our perspective. It's not only them, everybody does this, right? And I haven't really gotten into Taylor Swift, because if you research her, like, it's crazy. Like, it's just like, I was like, okay, I'm not gonna do anything. I'm not gonna speculate how much she was involved, because even Justin Baldoni doesn't say she was involved, right? He just says that Blake Lively has been mentioning, and she has. If you look at the videos, Swift did this, did that. So anyway,
I wanted to comment on what Susan Lust was saying, because I've heard a lot of people saying that the judge is compromised. I really don't think he is.
I don't think so. I don't think so either.
I don't see. I just because he's friends with what's his name. I don't think that I don't think that he's compromised. I think that his decisions have made sense. I don't think that him granting this motion to strike really means anything in the grand scheme of things. He's just a judge, and I've seen thousands of them now that are trying to control their courtroom. And you know, he seems like a sharp guy. I think that his rulings have been exceptionally beholden to law, and that's really the best you can hope for if you're a lawyer litigating in front of a judge. You just want them to get the law right, so that way you at least it's some aspect of the case is predictable. And so the motion to strike the docket entries was sort of predictable, because that kind of inflammatory allegations is something that belongs in chambers, not any letter published on the dockets that's going to be picked up by all of these people. And I know people may or may not get upset by that, but it's just understand, it's not affecting this case one way or the other. It's giving people the impression, I guess, that the judge is compromised, or that somehow the Lively party's got to win. It's not a win. It's literally just a behavioral thing. That's all, nothing more. We got Aquinetta. What's up, Aquinetta, with the $5 super sticker? Good to see you in here today. I hope you're having a wonderful Thursday. Yeah, I agree, Anita. I don't think the judge is compromised.
I want to give you maybe this is one of the things in my research what I was doing. So one of the messages, Blake Lively, when she's explaining why with the dragons, right? When she was explaining, she said that people look up to Ryan and Swift, not just for their acting, writing. Anyway, it's a long message. That message, do you remember that?
Which one?
More or less, the text message where Lively refers to them as the dragons.
Yes, of course I do.
So again, when I was doing this research, I tried to dismiss everything I know now. I think that really helped me. I was going as per the exhibit, and I was like, let's see, this is progressing, how it's going. I'm not looking at what we know now.
Right.
And one of the things that I realized is that Lively, she was surrounded by these people who are billionaires in their industry, and she was inspired, which I can imagine. The only problem is that she's not, and I mean it, this is my opinion, she's not as talented as they are. She has nothing to leverage.
Yeah.
And again, Taylor, some people say she doesn't have this thing, whatever it is, she's talented, at least she's a good business person. I don't know the details, but what if she hasn't come here without a talent of some sort, you know?
And she didn't know anybody? I mean, I have no, my understanding that how she's famous is she had famous parents. Is that correct?
Again, those are the things. I think like she not famous. I think like she came not from a middle class or like upper class family, and she was singing, and those are the things. Again, it would be speculation without evidence.
Yeah.
Whereas I feel like my speculation has evidence. I think I've backed up my speculations, if that makes sense.
Yeah.
And the thing is, like, when she came, when there's a Tim Miller, director of Deadpool, apparently, and he has released a statement that, oh, Ryan, he was a control freak and everything. The problem with Blake was that, and Tim Miller, he left on his own accord because he knew that Ryan Reynolds was the face of Deadpool and there was no way he could direct, and he knew that he didn't want to be a part of it.
Yeah.
The problem was that, again, Blake and that Ryan had a vision, and I think Ryan is driven by his trauma as a kid. It's all of his interviews and everything, his drive that he has, and joined with his talent. Regardless of who he is as a person, it has come to fruition in success and lots of money and power.
Reynolds, in his childhood trauma, has driven his success.
Yeah, he has daddy issues. Apparently, he talks about it. He talks about his human side and everything, right? So he actually, he may not be a good person, but bad people also have depth and intelligence, and he's intelligent, right? So this is how I perceive this whole thing. That's what I'm reading. And with Taylor, again, based on what she has the songs, they're popular hits, whatever it is, it's working, right? She is delivering something regardless of who she is as a person. And whereas with Lively, she has been trying and trying and trying. And the reason why she went so aggressive with this, and I'm saying like Colleen Hoover and her fandom, it's not just that it ends with us. You know, she could produce behind the scenes and everything. She went so aggressive because she needed this to prove.
Yeah.
And that's why I think they effed up, because they thought, and also I think Ryan Reynolds came to power on his own and he built it up, whereas she was like famous, and then she was surrounded by famous people, and then she tried to come with power instead of building up that power, if that makes sense. Sorry, this was very long, but I'm trying to explain, I think, why she was so aggressive for the takeover of the movie, allegedly.
Jealousy, insecurities, and ego.
Yeah, and her, like, how that's what it is. She actually didn't have the talent to back up, because when she tried to edit the script, and Justin was like, I think you have a different vision. And then she was like, all right, let me see when you're gonna be showing me birthing video, sexual harassment. I like, it all happened after that. Yeah. Sorry, that was a rant, but this is just, I think this is just like a human analysis of how I think why it ended up so bad for them.
That certainly was a rant, but a well-founded one.
You're no stranger to rants. I'm inspired by you. So
no, I call rants all the time.
Just a trick.
I know better than to interrupt a good rant.
I think it's important to understand. I think if you understand why people act a certain way, these legal filings, they don't, surprise you or anything. I haven't reacted to any of the filings, and I'm not outraged by anything, because I think I've put myself in their mindsets, although I don't know them. But
well, very few stuff has been decided in the filings. There's nothing to be outraged about just yet. You know, everything's still kind of up in the air. By the way, Jules Whitlow, despite like my rants about how I don't think that the judge is compromised, she says, I think he's getting paid off. Well, if that's the case, it's like I guess it would be sort of like the verdict with Paul Newman, 1982. That judge is paid off. The problem with paying off a judge is the jury is the final arbiter of truth. And just like in that movie, the judge saw through the defense's evil ways and found truth in Paul Newman's best efforts to expose evil, and it had a happy ending. If Judge Linman was somehow compromised, Ultimately, this is going to land in the hands of the jury. I don't know or think that the judge is going to be so compromised. Number one, I don't think that he is. Either way, just know this, that the jury is going to be the ones, if this goes to trial, to decide who's right or wrong. Not Judge Linman. He's just the referee ultimately at the end of the day. But, I've been wrong before.
I think Lyman has mentioned in one of the earliest parts is like he wants to be fair and he knows there's a great public interest, and that's why he didn't ask them to, like, he told Freedman, like, just be like, follow the conduct or something. What is it called? Like, and that's all. I think if he wanted to, he could have done it then. So even now, it was a slap on the wrist for that thing, but he didn't say what you said was wrong. So.
No, right. And he wasn't going to. He wasn't going to make any opinions about the merits of what he said. He's like, look, I can't do anything about it anyway. He didn't ask me to do anything. It has no effect on any actual cause in this case. What did you do that for? And then you know better than that. And if you do it again, you're going to get in trouble, is all he really said. That was all. There was a question. I should have started or something. Somebody asked a question about...
I'll be right back. I'll just listen. I'll be right back in the meantime.
Oh, that's cool. We're going to wrap up pretty soon anyway, but I had this question from T. Bonner. Omar, if documents are submitted under seal, wouldn't the document number in the docket skip? Not necessarily. The way that I've noticed the docket numbers, like, it's not that it would skip, but there's stuff under seal, like, for example, something for the judge's eyes only. Like, you would see it filed and you'll see like a portion of it, but you wouldn't get to see like the exhibits. And the exhibits would be Freedman's opposition to the motion to strike, attached to, his declaration attached to his opposition, and the declaration portion of it would be under seal. You'd never see that. You've seen that a bunch on this docket. There's a bunch of stuff that you see what's been filed. You don't see the attachments to the document. That's kind of how it would be. So you might know that they've been filed. You just wouldn't know what it was talking about. You know that there was a discussion about something, the contents of which would be hidden from the public and off of the docket. I think that's what you're getting at. Just Ricardo, what's up, buddy? Says that this ruling feels like veiled directions to BF. Oh, Bryan Freedman. Yeah, it's a don't ever do that again. I know what you're doing. You know what you're doing. And if it happens again, next time I'm going to take off the belt. Or, it's going to be more than an admonition. There's going to be an actual sanction levied your way. And lots of luck with that. So, I don't know if Anita is coming back or not, but
I'm back. I was just listening.
Oh yeah, so I was just answering some of these questions.
Before we wrap up, I know you want to go. Yesterday's thing, filing, because I remember you said that the Stephanie Jones lawyer was right in a way, like you see what they mean.
Not that she was right, just she was making good points. I was just wondering what the retort to that would be, because technically, I guess everything they did. Because the letter was basically just name one thing that we did was illegal. I'm not asking.
They have named it though.
And I know there was somebody that stated that they pulled information or they had metadata that gave probable cause to some of the stuff they were saying. I know that they're going to come back with an opposition. I was just stating that. That's a great point. And so her argument was there's not been an offer of proof as to probable cause to any of these criminal actions, and yet we're discussing it. So when I wasn't saying that they were right. I just saying that's a good point. They are going to have to frame that a specific way for the judge. That's why I was looking for the response to that. I guess it's forthcoming. Ellen with the 10 says Brian Freedman wrote that source. Brian Freedman wrote that source revealed 4 to 5 months prior to 2/14. Blake asked Taylor to delete text. So September, October is the last time Blake and Taylor were seen together. Isn't that also around the time of the sham subpoena? August. And then it was effectuated like in September, October. Is that right? Anita?
Phone was taken August 21st. Lawsuit was filed September 27th. Subpoena was October 1st. 4 days after.
Around the same time.
And that lawsuit dropped 1 day before the CRD, 19th.
Connecting some dots, man. Ellen, that's a great observation. And thank you so much for the 10, supporting the show. Folks, oh, wait, what is this? Narcissists sleep fine at night, unfortunately. Sociopaths do. Narcissists tend to be more schizophrenic. Well, I'm not a psychologist. I don't know. I'd have to ask Laura Knighty that question. She'd know better than I. But I'd have to consider that comment more deeply. Is that true? Or is a narcissist, would you consider that the equivalent of like a sociopath? Or would you consider a narcissist somebody that's so far up their own ass that they're like basically schizophrenic and like because I've known narcissists that were just like legitimately always on something. Like on some kind of like a melodramatic kick to the point where it just felt like they had no peace in their life whatsoever. Anyway, I'm rambling. That's a rant that has nothing to do with anything we're talking about.
I think if anybody has dealt with a narcissist, I don't think like everybody has encountered it in different ways, but when you see one, you know one. Like I don't have enough words to explain it, but when you see one, you know one. It's so easy to recognize based on actions.
Yeah. It's a word that's thrown around a lot, but they're difficult to pin down in definition. But, frankly, it's just somebody that's so ego driven, such as to not see anything that doesn't benefit or affect them. Lack of empathy.
Oh, sorry.
No, go ahead. I was done.
I'm gonna send you something because there was about the Stephanie Jones, the crime fraud exception revisited. Somebody posted like a very interesting and detailed breakdown of why this, like they do, how to say, Freedman like has the full right to pursue.
Well, send that to me if you want. Me and Lauren are supposed to stream. I told her I'd stream with her tonight, like at 8:00.
Oh, that's
probably your bedtime, huh? Yeah.
Oh no, I mean, if I'm up, I will listen, or like again, I will send it to you. I just want you to read it and see what you think, like legally, because I think again, with so much information and so much PR within the lawsuits, it gets confusing to decipher what's the facts stated or alleged.
I'll tell you what, I'll read it and I'll bring it up on Lauren's thing. And if you happen to be in the comments,
Yeah.
If you want to come on, just let me, if you're up and like,
I will be screaming. If you see anybody typing in capitals.
Oh yeah. That's how you get my attention. It's like, Omar, let me on. Okay. Anita has something to say. We do. Okay. All right, folks. That's all I got for you today. I'm going to be streaming with Lauren in a few hours. So look forward to that. Other than that, if I don't see you before then, programming update. I may or may not be able to do an episode of Flad tomorrow because I'm going on vacation. I'm going to have to, well, we'll see. I'll have some updates on my page soon enough. We'll see what happens. But I will see you guys next time. Have a wonderful day. Bye-bye.